Stephen is somebody that we've worked with going back, looking at conviction integrity units and other things, and he does a lot of innovation and quote-unquote best practices, or some innovative practices at the Miami-Dade State's Attorney's Office. So it's a pleasure to have him here, and take it away, Stephen.
Thank you. I'm really excited to be here and want to thank APA for inviting me and the University of Pennsylvania for providing me with this child-sized podium. I really appreciate it. I know that we are live streaming this presentation, so if you don't mind, I would just like to take the opportunity to say, "Hi, Mom, I'm at an Ivy League school. Finally got in. 52 years it took me, but I am here." So thank you for indulging me and my mother. What I want to talk to you today about is Miami-style smart justice. Before I tell you what I'm referring to, because I'm sure some of you are wondering, you may not have heard the term before. Before I tell you what I'm referring to, I want to step back and try to put everything into context. And the question begins with, who are we? What exactly do we do as prosecutors? And the answer is very simple. The comments regarding the rules regulating the Florida bar summarize a Supreme Court of the United States case and say, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. We're the only lawyers in the entire world whose job is to do the right thing every day, all day, in every case and scenario. Think about how awesome that is. I spent 8 years in civil practice. 8 years. Worked for a great firm. Love the people I work with. Toward the end of my tenure at the law firm, I did a presentation at the Miami State Attorney's Office, and I was talking to them about what it means to be a prosecutor. And I had an honest moment with them, and an honest moment with myself. And I said to them, I looked out in the audience, and I said, I know I have the job that most of the people in this room really want. I am a partner at a big firm making a nice salary. I know I have the job that most of you really want once you've built up enough experience to get it. But let me tell you the truth about our respective jobs. On my best day, I'd go home saving a corporation a few bucks. That's my best day. Maybe somebody notices. That's my best day. On your worst day, you know you've at least tried to make this community a better place. That means your worst day is better than my best day. And as I stood there talking to the prosecutors about this and about how wonderful their job was, I thought, what the hell am I doing? And made that call to the state attorney who, fortunately for me, brought me back to the office, because we are ministers of justice. We are special because we are trying to make a difference in our communities. Historically, we've all approached our cases in a very similar fashion. And it worked for a period of time. But times are changing, right? And as prosecutors whose obligation is to be a minister of justice, whose goal is to do the right thing all day and every day, we have to keep abreast of the research. We have to look at what we're doing. We have to look at what's happening and always challenge ourselves to think of ways to make things better. And that's really what we're going to be doing here today. So let's talk for a couple minutes about the traditional criminal justice system. The traditional criminal justice system is all about retribution, when we come right down to it. It's about retribution and restitution, and really that's it. Essentially, we set out to punish everybody we could, and if you started out the same way I did, you probably started out looking to incarcerate everyone you could for as long as you could, because we thought that was the only way we can adequately protect our communities. So we essentially focused on incarceration rather than rehabilitation. Now, I will tell you, 27 years later, 27 years after I started, incarceration is the single best tool we have for incapacitating somebody vis-a-vis the general public, right? I mean, if they're in jail or prison, they can't hurt somebody in the general public. It's not possible because they're in jail and prison. So it's the single best tool for that purpose. But it is not the only tool for that purpose and isn't always the best tool for that purpose. And that's really what we need to be focusing on, the best tool for the purpose. And we actually know that it is contraindicated in a lot of cases. This was shocking to me. The idea that if we over-punish somebody, we actually make things worse, not better. I didn't understand it as a young prosecutor. Now, of course, I understand it as a parent. What happens when we overpunish our kids? How do they respond to that? We all know the answer. It makes things worse, not better. It's the same thing with any other human being. I see a couple of you are taking notes. I'm going to ask you to not to. Here's what I'm going to do in exchange for your listening. So I'd like you to be thinking about what I'm talking about more than writing about what I'm talking about. In exchange, I will email it to anyone who wants a copy. And one of the reasons I'm asking you not to take notes, and one of the reasons I really want to email it to you, is you will notice on the bottom of a lot of my slides, I include some source material. And I do that for two reasons. Number one, I think you might need that source material, might want to review that source material so you can see this for yourself. But number two, I'm a firm believer, as we teach our young prosecutors, we arm the strong to defeat the weak. I want to give you the evidence, the research that supports the things that I am saying, so you could go back to the naysayers and say, no, here is some research that shows this stuff actually works. And this is the direction we need to take. So instead of taking notes, I'm just going to ask you to think about what I'm saying and digest it, and at the end I'll take any questions you might have. So what we know is that incarceration is contraindicated for certain low-level offenders. Now there's a decent amount of research out there, but I like to cite this particular research. This comes from a state agency. Okay, this state agency has no biases of any kind. Their sole purpose is to look at programs and analyze them and look at government accountability. That's all they do. That's all they do. This isn't some conservative or liberal think tank looking to empty our prisons or hammer everyone. This is a neutral state agency that is actually looking at the data. And what they did here is very interesting. They looked at people who are placed on community supervision, which in Florida includes probation as well as community control, which is a form of house arrest, and they compared the outcomes to a matched group of people who went to state prison. And what they looked at was the 2-year recidivism rates for these people. And you can look down those list of charges, and what do you see? You see a clear, consistent pattern that community supervision works better upon release. That's what you see. Again, this doesn't mean incarceration is a horrible thing that should never be used. What it means is we have to use it in a selective and appropriate way. And when we're talking about low-level offenders, we are best off not sending people to state prison as a general rule. We are better off placing them under appropriate supervision with appropriate programming that addresses their criminogenic needs. And I'm going to get more into that in just a couple of minutes. We also know something else. Even when we do send them to prison, it can't be a complete solution for the vast majority of offenders, because what happens when they're done with their sentences? They're released. They come right back into our communities. That's just the way it is. And when you look at the number of years they're serving, it ain't much, right? With murder, it's close to 14 years. The average offender in the state of Florida serves, or in the country serves 14 years of state prison. As you go down, they serve far less. For violent offenses, you're down a little over 2 years. Everything else is less. These people are getting out. Like it or not, they're getting out. So even if you're a hardcore, tough-on-crime kind of person, you've got to face the reality that these people are getting out. That means we have to take advantage of their time in prison, but it also means that sending people to prison when we know community corrections can work may not be the smartest thing for a lot of these people, especially those who are committing lower-level offenses. What else do we know about people who are sent to prison? When they come back, not only do they enter our communities, but they commit new crimes. That's the reality. If we don't take advantage of our prisons, if we don't tap into these people's criminogenic needs and address them while they're in prison, not only are they coming back in our communities, but they're coming back to commit new crimes. So take a look at these numbers. This is from 2018. It is a tremendously representative study. If you know anything about statistics, you know that you only need a representative sample to draw conclusions, right? So for presidential polls, we're talking like 3,500 people, 4,000 people, whatever it is these days. This is data from 70,000 people. There's no question that this is a representative sample. They looked at prisoners released in 2005 from 30 states. And the reason they looked at 2005 is because they did a 9-year follow-up. So this is not the kind of study that could be replicated very easily. 44% of these people were rearrested at least once in the first year of their release. Almost half. Think about that for a second. When I started as a prosecutor, I thought I send people to prison, they're never coming back, because who the hell would want to go back to prison? Well, apparently half these people are okay with going back, right? 68% rearrested within the first 3 years, 83% within 9 years. And the average number of arrests during this time was 5. We have to address the criminogenic needs. Incarceration alone simply does not work. That is the reality. And that, if you take nothing else from this discussion, please take that with you. Incarceration alone does not work except as an incapacitating tool while they're in custody. Incarceration is also the single most expensive intervention we employ. I don't know what it is in your states, but I promise you that's true. It's about 10 times as expensive as traditional probation. And I love this slide, which is again from Opaga in the state of Florida, because it gives a great example of the comparison. Prison in our state is $55.80 a day, right? Probation is $5.52. Even if you tack on big-time services to that, you may be looking at $10 or $15 a day. Much, much cheaper than the $55 a day we're looking at with state prison. We cannot incarcerate our way out of our crime problem. Can't be done. We simply cannot afford it. We've incarcerated as many people as we possibly can. We can't just keep building new prisons and sending people to prison for a long period of time. It doesn't work. So what is the alternative? The alternative is not to get rid of all the prisons and jails. I'm not advocating for that. I'm going to go back to what I said earlier. Incarceration has its place. It is a critical tool that we need to have at our disposal. What we need to do, though, is we need to focus on the offenders and their needs as well. Not just public safety, not just for the public, but the offenders themselves. Not just the crime, but the offenders themselves. What do we know about these offenders? The vast majority of people in our criminal justice system have tremendous criminogenic needs. A lot of them focus around substance abuse. I'm going to give you the stats. I know you're familiar with them, but I want to go through them because sometimes it's good to get a refresher, and very frankly, even people who have been prosecutors and in the justice system for long periods of time sometimes forget how incredibly significant these numbers are. So let's go through them quickly. We know that there's a link between drugs and crime. And I think the public understands that very well. What I don't think they understand is how significant that link truly is. An estimated 69% of probationers, 82% of jail inmates, and 79% of state prisoners use drugs prior to committing the offense for which they were serving time. 50% of whom had used drugs in the month that they committed the crime. Sure, that doesn't surprise anybody. Frankly, I was surprised it was that low, to be honest with you. The next slide is much more telling. 14% of all probationers, 18% of all felony offenders, 8% of all misdemeanor offenders, 35% of local jail inmates, and 31% of state prisoners were under the influence of drugs at the time they committed their offense. Do you think these people are thinking, ooh, I better not do this, I might get caught and go to jail or prison? They're not thinking that. There's no way they're thinking that. This is the problem we are dealing with. Only 3.5% of the general population meets criteria for drug abuse or dependence. 3.6%. Think about that number. Now compare that to what we're seeing in the criminal justice system. 12.3% of people under supervision. 63% of jail inmates and 58% of state prisoners meet criteria. That's one heck of a correlation, don't you think? To me, it's a lot more than that. To me, that shows a causative link. When the numbers are that extreme, when the difference is that extreme, it demonstrates a causative link. We have a problem. These people have a problem. It has to be addressed. We ignore it at our peril. What about alcohol? We hear all this discussion about the link between drugs and crime. Nobody ever talks about alcohol. And that's a real problem to me as a former DUI prosecutor, right? Because we know that alcohol, the link between alcohol and crime is tremendous. And it's not just DUI, it's domestic violence, it's violent crime, it's basically everything. Everything that drugs are linked to. So I want to give you these numbers. Now I'm going to start with a report from 1998. And you may be thinking, who is this joker who's going to stand up here like he actually knows what he's talking about, citing 21-year-old data? What is wrong with this guy? He couldn't find something newer? The reason I'm citing data this old is because this is the last time anyone bothered to take a comprehensive view of alcohol and crime. And it was actually the Attorney General of the United States who had all this done. Can you imagine that it's been this long since we've really taken a hard look at alcohol and crime nationally and looked at all the national numbers? It really has been. So here's what they found, and these numbers are just staggering. More than 36% of the 5.3 million convicted adult offenders under the jurisdiction of the government, be it jail, probation, prison, whatever it might be, had been drinking at the time of the offense for which they were convicted. That's over a third. The average BAC, and I love these numbers because they're so telling, they tell such an important story. The average BAC of probationers who were drinking before they committed their offense was a 1/6, double the illegal limit for driving, right? Here's what's really interesting though, and this is what's shocking to a lot of people. Among state prison inmates, it was triple the illegal limit. You see, the more violent the crime, the more serious the crime, the more likely it is that alcohol and drugs are involved. That's one of the amazing things about this whole thing. We think that the people who have drug and alcohol issues are the low-level offenders. And, well, they are. But proportionally, they're even more represented among the higher-level offenders. We have to address these people's criminogenic needs. It's really that simple. They did a survey in 1997 of inmates in state and federal correctional agencies that provided additional insights. The more violent the crime, as I said before, the more likely it was that drugs and alcohol were involved. According to this survey, 40% of state prisoners who committed violent crimes did so under the influence of alcohol, 44% under the influence of drugs. Alcohol and drugs, the percentages are basically the same. Everyone thinks drugs are so much worse. It's not among this population. This is one of my favorite statistics. When I showed this to the state attorney, she had me go back and pull the page because it sounds so ridiculous that she had trouble believing it without seeing the source document. Over a third of probationers said they drink a fifth of alcohol in a given day. That's a lot of alcohol, right? I mean, that is a tremendous amount of alcohol. Almost a third of all convicted inmates in local jails and almost 30% of state prisoners describe themselves as daily drinkers. Again, none of this should be surprising. What about mental health conditions? Because, of course, it's not all about substance abuse. Approximately 64% of jail inmates and 56% of state prisoners had or have mental health problems. Think about those numbers for a second. In one recent survey, 44% of jail inmates and 37% of prisoners reported being told by a mental health professional that they had a mental health disorder. 26% of jail inmates, 14% of all prison inmates met the threshold for serious psychological distress in the last 30 days. You know where the greatest number of people suffering from mental health problems are in our country right now? Jail and prison. That's where they are. We are the ones dealing with them. We're not, which is why our recidivism rate can be as high as it is. So now let's compare that to the rates of the general population. I love this slide because it visually shows what we're dealing with. You can see that the percentage of the general population with similar mental health issues pales in comparison to those we're dealing in the criminal justice system. Again, shouldn't be a surprise to anyone, but the numbers are quite stark. When we don't address these issues, when we don't address the substance abuse issues, they're going to keep coming back. It's just really that simple. And of course, the research says that inmates with mental health issues are more likely to have a history of violent crimes and substance abuse than other inmates. Of course, these two things often go hand in hand, substance abuse and mental health issues. 64.5% of the inmate population meets medical criteria for substance use disorder, 7 times the general population's numbers. Almost 25% of jail and prison inmates have both a mental health condition and a substance abuse disorder. Staggering numbers. The question is, what do we do with these numbers? What do we do with this information? What do we do with the fact that we know the vast majority of the people we deal with each and every day have substance abuse issues and or mental health issues? What do we do with this information? Traditionally, we ignored it, right? And we just hammered everybody. Didn't work. We know it doesn't work. The recidivism numbers tell us it doesn't work. Well, we have a different vision in Miami. It's one we've been practicing for almost 30 years. Our vision is a vision of smart justice. And what we're talking about is smart, effective, and responsible justice. It's where we consider things like public safety, which is our absolute #1 priority. Make no mistake about it, public safety is our #1 priority. And we look at things and we think about the fact that people are individuals. We don't prosecute people as groups. We prosecute them as individuals. We prosecute them as persons. We stay abreast of the research because we want to know what works and what doesn't work, and we try to engage as much as possible and use evidence-based practices. And I'll tell you, this could be very challenging, particularly when you're being innovative. And I'm going to talk to you a little bit about that in a few minutes. But you've got to understand at least what's happening in our community, what's happening with these people, so you can address them. We systematically assess and address their criminogenic needs, not just the actions, not just the crimes themselves. And we seek to maximize our limited public resources. How many of you have heard of Miami, right? I mean, we're a fairly large jurisdiction. People know that. We've got 2.7 or so million people in our jurisdiction, right? We deal with a ton of people. In order for us to get anything done, we have to be efficient. We have to use our resources in a strategic way. And that's really what I'm talking to you about right now. I'm talking about being strategic in how we address crime and how we use our resources. And we try to do everything I've just described simultaneously. And to an extent, we're actually pretty successful doing that. Here's the reality. And this is an added benefit. We hear people talk about how much one day in the system matters to people. Doesn't seem like anything to us, particularly when we get to the higher levels and we're negotiating by the decade. But every day matters to the people who we're dealing with. It matters to the defendants. It matters to the victims. Closure is critical, and speed is very important to all of them. What we want to do is we want to quickly resolve cases so that we can do it in a fair way and an appropriate way, maximizing our resources and focusing them on the people we're scared of, not simply the people we're angry at. Right? That's how you reduce crime. So how do we go from this theory, this almost utopian sounding theory, right? You think, how can this possibly be done? How do we go from this theory to practice? How do we get to the idea where we create and implement programs that can reduce our expenditures while at the same time improving public safety, restoring lives, and relying less on incarceration? How do we achieve that? Is that simply a dream? And the answer is no. This actually happens. We do this every single day in Miami. I want to talk to you first about our civil citations. How many of you use civil citations? This didn't even exist when I started in 1992. If I could roll back the time and speak to myself as a first-year prosecutor and someone had suggested civil citations, I would have thought they were crazy. But this actually exists and it actually works. Essentially what these do is they allow the police officers, instead of making an arrest, a criminal arrest, what they do is they issue a civil citation to somebody. And we use this for low-level crimes. So what happens is an officer, and I'll take marijuana as an example, an officer, instead of arresting somebody for possession of marijuana, which is still illegal in the state of Florida, instead of making an arrest for that charge, they may issue a civil citation where all the person has to do is pay a fine. Much better solution, right? Keep them out of the criminal justice system. Don't divert them once they're put in. Keep them out altogether. And we do civil citation for a host of low-level offenses, primarily for juveniles, but also with adults. When we started the program, there was a concern, and I'm going to give you statistics in a few minutes, there was a concern that the program would cause a net widening. And what I mean by that is there was a concern that the officers would go to somebody they wouldn't have arrested, but now they're going to give them a civil citation. Somebody they would have just warned and let go, and now they're going to do something to them when they wouldn't have done something to them before. There was actually some research done on the program, and they found that that was absolutely not happening. There was no net widening in the state of Florida with our civil citation program. We all breathed a nice sigh of relief and expanded our program. So the one we're most proud of is the one with juveniles. We started this program in the state of Florida. It's now statewide. It is created by statute. I'm going to give you the Miami numbers only. These are Miami numbers. They're huge, so remember, we're Miami. So we've had over 20,000 juveniles cited in lieu of being arrested since we started this program. That's 20,000 juveniles who would have gone into the criminal justice system but are getting a civil citation instead. Think of how awesome that is. In 2018, we had 835 juveniles cited instead of arrested. 2018 alone. 83% of the people who are cited create the program. In the case of juveniles, they're going to do more than simply pay a fine, but 83% complete the program. Only 4% are rearrested. So the numbers are really good for these programs. They work. I mean, it's really that simple. Most people, particularly juveniles, at low-level offenders, will learn from the arrest experience or citation experience itself. And by the way, I'm not going to go into detail on any of these things. I'm basically trying to give you examples of the kind of things we're doing. Bail. There's been a big movement in this country, as you know, to eliminate monetary bond. We have not eliminated monetary bond. We believe that monetary bond, like incarceration, has its place. Everything has its place. We're not ready to throw out all the tools that we may have at our disposal. What we want to do, however, and what we have done, is look at a way where we can more strategically use each tool, including monetary bond. So here's some of the data that we looked at and some of the conclusions we reached. This is data, again, from an OPAGA report in December of 2017. And what they did was they looked all around the state and they looked at the people that were being released. And the question they asked is, of the people who were being released, what percent or how many were issued a warrant for failing to appear in court, and how many were arrested for any offense while out on pretrial release? Okay? Those are important things to know. What we found was that only 6% of all these people failed to appear in court and they had to issue a bench warrant or an alias capias. And only 5% were rearrested for a new offense. What does that tell us? What it tells us is that in basically 95% of our decisions to release these people on a non-monetary bond or on a low monetary bond, these people are going to show up in court and they're going to refrain from committing additional criminal activity, or at least not get caught committing new crimes, right? So that tells us that we can safely allow these people into our community if we make good decisions on who we're selecting to release or allow to be released. That's important for us to know. So then we went in and thought, well, what about low-level offenders? What does the research tell us about low-level offenders? And there was a publication in the American Economic Review that we thought was very important. What it told us is that offenders who are detained pretrial recidivate ultimately at a higher rate than those who are released. And it's a significantly higher rate. We also found that pretrial release increases employment even 3 to 4 years after the bail hearing. And that's because they don't lose their jobs, their family life isn't destabilized, they maintain their housing, everything works, they're able to function better in our society. So the bottom line is, for low-level offenders, we have found, the research has showed, and we found in our own experience and believe based on our own experiences, that we are better off when these people are released than when they are held pre-trial. So here's what we did. After going through all the data, we changed our policy. And this is new. This is something we've done in the last few months since I rejoined the office in April. This is brand new. I told you, we're always looking for ways to do things better. We're always looking at ourselves. We're not afraid to have these conversations. Here's the end result of the conversations when we looked at the research. We now recommend that the court release all defendants charged with a variety of crimes, including possession of marijuana, petty theft, and other crimes on their own recognizance during the initial bond hearing. Now, of course, there are exceptions to this. If we get somebody who's been arrested 78 times for petty theft, we're not going to be too excited about releasing them on their own recognizance. So every rule has an exception. But as a general rule, we are releasing all these people on their own recognizance because we feel like they're going to do better out in the community than they are sitting in a jail awaiting trial. It's a tough decision. It's one that is not particularly popular in a couple of our neighborhoods, but it's the right decision. And the research supports it, and that's what we as prosecutors do. We make those tough decisions. Post-arrest diversion. We've created and implemented a whole slew of diversion programs, many of which you probably have in your jurisdictions. We have diversion programs for theft, for non-violent weapons possessions. We even have one for gun possession, although it's very, very rarely used for obvious reasons. It's only for exceptional situations. We have programs for driving with license suspended. We actually help people get their licenses back because we know how important that is to them. We have diversion for domestic violence and for DUI as well. All of these programs are designed in a way to address each defendant's criminogenic needs. In a DUI diversion program, for example, every defendant undergoes an evaluation with a standardized assessment tool to determine whether or not they have an alcohol or drug problem. Not surprisingly, most of them do. And what we do is we then require them to address those issues prior to program completion. So we're very careful to make sure we're dealing with people in a strategic way, even within our diversion programs.
Last question.
Yes?
Within domestic violence, do you make determinations about the risk of safety and the violence of the offense? It seems different than everything on the list.
We generally do, and the conditions vary according to the offender. We typically require, actually in every domestic violence case, we require them to go through a domestic violence intervention program. So they go through a whole program which includes things on anger management and everything else, better ways to interact with other people. It's exactly what you would expect in any kind of domestic violence program. So yes, we do that. In terms of juvenile diversion, we like to cite this as an example because realistically speaking, the best time to do an intervention is at the earliest possible moment, right? So if we could get to them as juveniles before they become adults, we have a better chance, particularly while their brains are developing, to make a difference in these people's lives. So there is some research out there, and I've given you a cite for one of it, that suggests that juvenile participation in diversion actually reduces recidivism. Again, no great surprise. In 2018 alone, more than 1,500 juveniles participated in our diversion programs. We had a completion rate of 77%, and only 8% were convicted of a new crime in the 12 months after they completed the program. So the numbers are pretty good. They're not perfect, but they're pretty good. Adult diversion, just to put this in perspective, how big our programs are. 2018, we had 7,000 misdemeanor offenders and 1,700 felony offenders go through our adult probation or diversion programs. And as with juveniles, research suggests that these programs also can reduce recidivism. Yes, sir?
Out of how many cases is that?
Oh, good Lord. Let's see. I want to say we had 25 or 26,000 felony arrests in 2018, and God, the juvenile numbers I haven't looked at in a while. I would, if I had to hazard a guess, and this is just a guess, I would guess we're around probably 60,000. I mean, the numbers are huge. Our numbers are very large on misdemeanor cases. One of the issues we have with diversion, by the way, as an aside, because you're probably wondering why the usage seems low relative to those numbers, is a lot of defense attorneys would prefer that their clients take a withhold credit time served or a withhold and pay a fine. Withhold doesn't count as a conviction in the state of Florida, rather than participate in diversion because they don't want their clients to have to go through all the programming and be monitored and do all the other things that they have to do. So they think it's easier for their clients just to take the withhold. Particularly because in Florida you conceal and expunge after your first one if it's a misdemeanor. Yes?
What does that mean?
What happens when somebody pleads guilty or no contest in the state of Florida, they can either have a withhold of adjudication or be adjudicated guilty. An adjudication is considered a prior for all purposes, prior conviction. A withhold is not considered a conviction for our purposes. Now, if you talk to the feds and ICE and all those people, they look at it a little differently than we do, but for our purposes, it doesn't count as a conviction. There's very little research on diversion programs, and they vary so much that I hesitate to provide you any data because unless it's on your particular program, it's hard to make any sense of it. But there is research that suggests diversion programs can work. Problem-solving courts. Before I talk to you about problem-solving courts, I want to tell you a little bit about my journey and how I ended up where I am today. So I'm going to take you back to 2003. In 2003, I was an 11th year prosecutor at the Miami State Attorney's Office. I had spent, in the mid-90s, I had started and ran our gang unit, our investigative gang unit for several years. I had, at any given moment, between 8 and 9 police officers and special agents detached to me. I ran RICO investigations, left and right. We were indicting 30, 40 people at a time, wiping out criminal street gangs and cleaning up neighborhoods and doing what a traditional prosecutor does. After that, I spent a year as a homicide prosecutor, as a felony division chief, before going back downstairs as our county court chief because I wasn't satisfied that we were hammering DUI offenders the way I thought they needed to be hammered. 2003, I get a fellowship with the National Highway Traffic Safety Administration, NHTSA. And my program manager calls me up one day and she says, I want you to go around the country and talk about the importance of DUI treatment courts. And I said to her, treatment courts? Are you kidding me? These people don't need treatment. They need jail. And when they're done with jail, they need prison. And when they get out of prison, I'm going to send them back. Treatment? I'm not doing that. And she says to me, I want you to do your due diligence. And if you still feel that way, we'll figure out what we're going to do with you. And I don't know about you, but it's a little disconcerting to have somebody working for a federal agency telling me they're going to figure out what to do with me. But that's what she said. And I thought, okay, no problem. I've been a prosecutor 11 years. I've been in an investigative unit. I know how to do an investigation. I know how to make an argument. I spent literally hundreds of hours. I read every single article, study, publication, blog post, you name it, that had anything at all to do with drug and treatment courts. Can't do that today. There's way too much. But in those days, it wasn't a lot. And frankly, there's probably stuff I missed because my internet skills were so bad. But I read everything I could get my hands on. I spent hundreds and hundreds and hundreds of hours. And at the end of all that research, I realized I was wrong. I was on the wrong side of the issue. And what I like to say is that I've now spent the last 15 years doing my penance. And that's what this really is. Because the fact and matter of these courts work. And let me tell you what the research says, because I've read it all. This is what it says. If you do a poor job implementing your program, it will not work. Shock. Here's the surprise, though. If you do a poor job implementing your program, it will also not, in all likelihood, increase recidivism. That was shocking to me. But much more importantly, if you do a good job implementing your program, you can dramatically reduce recidivism and do it far cheaper than you can by incarcerating people. Not only can you do that, but you can give these people back their lives. How awesome is that? You can do your jobs to improve public safety, and you can do it in a just, fair way that saves money and gives people their lives back. Think about what you're accomplishing as a prosecutor when you can do this. This is awesome. This is absolutely amazing. I love these courts. So here's what we have in the state of Florida. We have drug courts, mental health courts, veterans courts. We have all sorts of different programs. In Miami alone, we have several mental health programs. We have an adult drug court, and we have a veterans treatment court. And I'll tell you something funny, which also reflects on how insanely arrogant I was back in 2003 and 2004. Do you know where the first drug court in this country was started? Miami, 1989. Janet Reno partnered with the then public defender and then chief judge to start that drug court. Here's what you wouldn't know, you couldn't know. Janet Reno had a chief assistant at that time who implemented the drug court. It was actually that chief assistant's idea. That chief assistant took over for Janet Reno in 1993 and is still the state attorney to this day, Catherine Fernandez Rundle. When I decided to trash these programs in 2003, it was knowing full well that my boss implemented the first one, thought of it and implemented it. That's how crazy I was. Right? So now I've learned a second lesson. I never question my boss anymore because she's always right. Even when it doesn't make sense to me. But it actually does make sense. It makes sense because we're addressing these people's criminogenic needs. And I want to run through this real quick with you. So in 1993, 4 years after we started our program, researchers went in, took a look at our program and did some very, very, very preliminary research. I mean very preliminary. And what they found was that our drug court actually works and that participants had lower incarceration rates and lower rearrest rates than non-participants. Not a great study, I'll tell you that right now. If you look at it and you're in a study with rigorous standards, this ain't it. But it gave us at least an idea that we were doing something right. So we dramatically expanded our program. And as we expanded our program, more research was done. And as a result of that research, we're actually now closing in on 4,000 drug courts around the country. And there's a whole slew of research. Again, this is why you don't want to take notes. A whole slew of research that's out there that talks about how great these courts can be when they're implemented properly. So again, I'll give you the presentation and you can go check all this stuff out for yourself. In 2018, we had 686 felony offenders go through our drug court. That's a lot of people. That's a lot of people who would be sitting in state prison but for this kind of program, or county jail. Mental health courts. We started our mental health courts back in the 2000 area or so. I was county court chief when they really caught on in the county court division and took the same lovely approach that he took to drug courts and was proven wrong once again there. These are designed, obviously, to address people with mental health issues. There is some research that is out there. Again, it's not great research. There's still a lot of research to be done, but it does suggest that the people who go through these programs are less likely to recidivate, less likely to be arrested than those who do not. In other words, there's at least preliminary research showing that these programs work. Yes, sir?
You said that if the drug court is implemented properly, it works, and if it doesn't really do anything. Can you give us a feel for poor implementation versus good implementation?
Sure. Poor implementation is a program that doesn't do an adequate job and doesn't use validated instruments to assess somebody for a drug problem. A poor program does not adequately monitor their offenders. These courts, when they work best, are accountability courts. The people who are in the courts, the participants, are heavily monitored. Ours are drug tested on a regular basis. They appear in court on a regular basis where the judge addresses them and speaks to them and talks to them about their situation. People who violate in our court may be given flash incarceration. In some courts, a person violates 1 or 2 times and they're thrown away and they're slammed. Not appropriate. None of those, the courts that don't do the things that we're doing do not work nearly as well as we do. You need to, the National Association of Drug Court Professionals, and thank you for this question, I'm so glad you asked this. The National Association of Drug Court Professionals, NADCP, maintains a website which is an invaluable resource, and they have a whole bunch of things up there that are important to this discussion and to you if you want to do something like this. One of those things are the guiding principles for a drug court. And what they do is they talk about all the different things that an appropriate drug court should be doing. They're very, very helpful. I will tell you, though, they're not sufficient because they don't come down to the level of detail where they really tell you exactly how it would be implemented. NADCP provides training, a whole training curriculum. There are grants available to all of you to go through these kind of training programs where they will teach you how to properly design and implement a drug court and who you should be bringing into the drug court. One of the things that has happened historically is we've used drug courts to address low-level offenders only. What we've learned is that we can address higher-level offenders. Obviously, there's some we can't because they need to go to prison, although a reentry drug court can address them. But we've learned that we should be focusing on how significant the drug problem is. So I'll give you an example. When I started back in felonies in 1995, if I had a cocaine possession charge, that person went to drug court. It was great. I loved it. It was a great way to get rid of my cases. Boom, straight to drug court. Problem is, I was sending people without any regard for how significant their problem was. Some people who are low risk, low need, don't need a drug court. It's useless for them. It's not going to change anything. It's like giving aspirin to somebody with no headache. Some people who are high risk, high need, on the other hand, really benefit from drug courts. So those are the people who belong in a drug court. So what we're seeing is the drug courts who are addressing people who are low risk, low need don't have a significant impact. The drug courts who are addressing and doing it properly for people who are high risk, high need of recidivating because of their substance abuse issue, tremendous difference. Probably a lot more than you wanted, but I couldn't help taking advantage of that, so thank you for that. So our mental health diversion program was actually created based on a grand jury report. Our grand jury looked at mental health issues in Miami. I know it would be shocking to all of you to know that we have a very significant problem with homelessness and people with mental health issues who come down to Miami for the warm weather so they don't have to suffer through your winters. So we have a lot of people with serious issues who we really need to help and have been striving to help. One of the things that's not on this slide is our officers are all, not all, but a huge percentage of them trained for crisis intervention to try so that we don't escalate situations involving these particular people on the streets, and that program has been an incredible benefit. So in 2018, we had 82 misdemeanor and felony offenders participate in our programs through court, and we found that the recidivism rates are much lower. We actually were able to close a jail facility because of our programs, because of our police program. They're no longer arresting these people, they're diverting them, they're making much more liberal use of the Baker Act statute, which is much more appropriate than simply bringing them into the jail, and we're getting much better use. We actually closed the jail facility because of this. We have a veterans treatment court. We've now had 42 people go through the court during the last 3 years. This court tends to take a lot longer than the other courts because we're dealing with people usually with very, very significant mental health issues, PTSD, and they can be very violent. So we have a lot of difficulty with the participants in this court, but so far so good. Our recidivism numbers are frankly much lower than even we expected, which I'm very happy to report. I don't have actual numbers for you because frankly they're so small they're not even worth reporting, but so far so good. This brings me to community outreach. So a lot of people think that the prosecutor's job ends when the sentence is entered. And we disagree with that fundamental philosophy. We don't think justice ends anywhere. We think we are responsible for everything that goes on that relates to the criminal justice system, including the collateral consequences of a conviction or an arrest or anything else that may come out of the criminal justice system. So about a decade ago, we started a program that we refer to as our Second Chance program, and it's basically a program that facilitates people in sealing and expunging the cases that they can seal and expunge under state law. And to give you an idea of how serious we are about doing this, we've held 82 events since 2011 where we send one or more prosecutors, usually 2 or 3, and several of our staffers out into the community and help these people go through the process. And we do this in collaboration with the public defender, who sends a representative to provide counsel if needed, the clerk's office, who actually sends their clerks out, and our own investigators who are there for fingerprinting purposes. So a person shows up, we run their record, we decide whether or not they're eligible, we identify the offense that they're eligible to seal and expunge, they go and they get fingerprinted, they come back to us, we sign off on all the paperwork, it goes to the clerk gives them certified copies of the records, off they go. Everything's done. Now all they have to do is send it into the Florida Department of Law Enforcement, who processes it, verifies everything, sends it back, they go to court, order signed, record sealed or expunged. So we take a process that could be very confusing to the average citizen, and we make it as simple for them as possible, and we literally walk them through the entire process. We've helped a heck of a lot of people doing this. Over 11,000 people have requested our assistance. We've been able to help over 6,000. And the numbers, of course, are increasing as the public better understands this. One added benefit of programs like this that we don't often think about as prosecutors, which to me is very important, is community cooperation. When the community knows that you're out doing the right thing, when the community knows that you're really all about justice, not just about hammering people, we get cooperation. So how does this play out in real life? Homicide occurs, right? The number one challenge we have on homicide cases is getting witnesses to cooperate, to come forward and cooperate. What we have found, and this is anecdotal, we can't prove this statistically, but what we believe is happening is people are much more likely to cooperate with us today than they were 10 years ago because of programs like this where we're going out into the community and letting them see that we're really here to help. We're not just looking to hurt anyone. We're really here to help. So programs like this we feel are very, very important. Here's another one that we're particularly proud of, and I'm particularly proud of this, frankly, because it's such a gutsy thing to do, and I was part of the team that put this together. So what happened was in 2018, the public decided to pass a referendum, a constitutional amendment restoring the right of most offenders who are convicted of a felony to vote. That's a big deal. We were one of only 4 states in the entire country where a returning citizen could not vote because of a felony conviction. And this applied to all felonies, even things like possession of cocaine. It applied to everything. The new amendment allows all these people, with the exception of those convicted of murder or sexual battery, to be able to register to vote. So we looked at it, and we were trying to figure out what was going to happen. The legislature came in, and the legislature passed a law on implementation of the amendment. And what the amendment talked about or required was that the returning citizens complete their sentence before voting. What the hell does that mean? Complete your sentence. So the legislature came back and defined those terms. Some people thought completing a sentence meant finishing their jail or prison term. Others said, well, it might also include probation. Some said it includes fines, fees, and costs. What does it really mean? Who gets to decide that? Well, the legislature felt that they did. So they passed a statute to implement that law. And under that statute, there's been a whole issue raised all across the state as different jurisdictions looked at the statute differently. My state attorney, Kathy Rundle, sat down and said, we got to find a way to make this work. We need to implement the law in a fair and just way, and we're going to make that happen. And we sat down and spent literally 100+ hours each figuring out how we were going to implement this law. And what we ultimately came up with was a plan to help all these people determine if they were eligible to register to vote, and then create a process so that they would be able to do that. And that process includes our creating forms with the public defender's assistance, affidavits of indigency, 3 different types of motions that we created for these people, 3 different types of orders that we wanted the judges to sign, and a whole court process, 3 separate court processes for the different groups of people coming through. And I can give it to you in great detail, but for this discussion, it's all that's really important is that we took something that looked very unworkable and made it workable in our jurisdiction. And we took into account people's ability to pay, because our basic position is that people shouldn't be prevented from voting because they cannot afford to pay their fees and costs. It's really that simple. And we were the first jurisdiction to do this, and now 2 other jurisdictions have filed suit. But we're right now the only one where the process is already up and running. And we're very proud of this, because this, we feel, is part of our obligation as ministers of justice. We saw an issue, and we dealt with it. We dealt with the collateral consequence of the felony convictions in a situation where there were many people telling us it wasn't our jobs, and we had the guts to do it. We had the guts to do it. Nobody likes to be criticized. But in the end, we're ministers of justice. We do the right thing. And it's really that simple to us. So, I want to do 2 things. One is I do want to recognize our collaborators. I know we're starting to run out of time, but I really do think it's important. And I think it's important for 2 reasons. Number 1, I think it's important that they get the credit they deserve. But number 2, this is what happens when you approach criminal justice the way we do in Miami-Dade County, the way my state attorney does. You'll see on that list of collaborators, it's my state attorney, Kathy Rundle, Carlos Martinez, the public defender, Gene Zanobi. We have a conflict counsel. We're so huge, and there were so many conflicts that the PD had with their clients that we actually had to create a whole other office that's like the backup to the PD's office, and that's the conflict counsel, Gene Zanobi. Our clerk of courts, our chief judge from the 11th Judicial Circuit, Bertie Soto, Senator Jason Pizzo, House Democratic leader Keone McGee, and Desmond Meade. Desmond Meade himself is a returning citizen. He's the head of the Florida Rights Restoration Coalition. And he's the one, and his organization is the one that pushed this initiative statewide and got it passed. So why am I going through all this and telling you all this? I'm telling you this because we approach justice in a holistic fashion. We work very closely with the other stakeholders to get things done. If we didn't do things like this, none of the programs, none of the things I've talked about would exist. You've got to work together. You've got to be willing to reach across the aisle, as they say in national politics. You've got to be able to reach across the aisle and talk to the people on the other side and the people around you, and especially the people in the community, to get their buy-in in order to do the kind of things that we do. And when you do, the results can just be fantastic. So in terms of restoration of voting rights, the second thing I always like to do, and every time we do a new program, we have to go this route. Because in the end, it's all about public safety for prosecutors. That's what the public expects and wants, that we engage on public safety. So every time we do something, one of the things we look for is say, what is the impact on public safety and on recidivism? And what we found is that there's actually research out there, and this probably won't surprise anyone, that says when you start restoring people's rights, when you make them feel like they're part of society again, when you stop ostracizing them, recidivism goes down. Makes sense, right? You start making people feel like they're part of the community again. It matters. All this stuff matters. And that's why this stuff works so well. So I'll leave you with this thought. It's good to be tough on crime. It is. And there are plenty of offenders you need to be really tough on. You need to. There's no question about it. We still seek the death penalty at the Miami State Attorney's Office. There's no question. There are plenty of people we either have no interest in rehabilitating because we think they're done. They've done something so heinous we're not worried about rehabilitation. Or people that we have to incarcerate for long periods of time simply because they're way too dangerous to let out. The rest of them, may be good to be tough on crime, but it's most important to be smart, strategic, and responsible in addressing that. So thank you very much. I appreciate your time. Does anyone have any questions I can answer? I've got 5 minutes, apparently. Yes?
You've obviously been working on this over many years and have initiated a number of programs. Can you give us a feel for what kind of resistance you encountered in initiating such programs?
Oh, God, I love that question. Thank you. I couldn't have planned a better question. I love that one so much. Yes, the number one problem you will have in initiating these kind of programs, someone like me. You're going to deal with people who are going to look at them and say, this ain't a prosecutor's job. That's not your job. Your job is to convict people. Your job's not to empty the jails. Your job is to put people in those jails. Your job's not to worry about the defendant or worry about the defendant's family. Your job is to punish him. Your job's not to rehabilitate him. Your job is to hammer him. Your job is to worry about public safety. And to some extent, there's truth in those things. There is some truth in those things. But you know what? It's also your job to do all the other things I've described. So how do you deal with somebody like I was in 2003? You show me the evidence. Because what it all comes down to, what do we as prosecutors always care about? What do we do every time we file a case? Every time we try a case, what's it really about? It's about the evidence. We're always looking at the evidence. We're always looking for a way to build things. So that's one thing. Show us the evidence. The evidence is critical, and that's why I'd love you to email me for the presentation and send it to you, because I want you to have the evidence and at least get you started on your journey down the path that I've taken. Here's my contact information. So it's first about the evidence. The second thing is, tap into what you know is there for the stakeholders in your community. More than anything else, I became a prosecutor because I wanted to change the world. I wanted to make a difference. I wanted to do something special. I wanted to do something great. And I feel that's what I have the opportunity to do as a prosecutor. When we become prosecutors and stay prosecutors long term because of an affinity for our communities and public service, right? I mean, you know, we're sure not getting paid enough to stick around for any other reason, right? So we're in these positions because we want to be. This matters to us. We're working, especially at the higher levels, for much less than we can make in a private community because we actually care. So when you reach out to your prosecutors or leaders or other stakeholders, that's what you've got to tap into. That's what you got to tap into. And third, you got to tailor your arguments. So, you know, you hear people on one side of the aisle talking constantly about we need to eliminate mass incarceration. And their focus traditionally has been on the defendants and the defendants' families. And they talk about, you know, the impact on them and justice impacted people. When I say justice impacted people, I'm talking about victims, not defendants and their families, as a general rule, right? Because my mindset's a little bit different than theirs. But they're talking about it from the left, and they're talking about the need to help defendants and their families. I'm coming from the other side, but you know what I'm looking at? I'm looking at resources. I'm looking at it saying it makes no fiscal sense whatsoever to be incarcerating somebody on a low-level crime if I've got a better way to address what they're doing, if I've got a cheaper way to address it that also benefits public safety. So the point of this whole presentation and the way I structured it the way I did is exactly because of your question. No matter how you slice this stuff, there's something in it for everybody because it works on a whole host in a whole host of areas. This is the beauty of what's happening in criminal justice reform today. We look at what's happening in our country. You identify a problem, and it's a partisan problem, almost across the board. It's almost impossible to find something that is not partisan until you get to this. This has something for everybody. because what we're doing is we're being strategic and we're looking at ways to address everybody's needs in a way that makes sense for everybody. That's really what we're advocating. So we're never going to agree, I'll look at a case where a criminal goes and tries to kill somebody or succeeds in killing somebody, and I may think a life sentence is appropriate, and I'll never agree with someone who tells me that 5 years is appropriate. That ain't going to happen. That's a sliver of the criminal justice system. The vast majority of the people in the criminal justice system are people who these programs actually matter for, either as pre-arrest, diversion, part of probation, or on the back end as part of reentry, which I really haven't talked about. There's always a way to get to these people in a way that is better than simply throwing them away or warehousing them at the level that I'm talking about. And that's the key. Does anyone else have any questions?
So I guguess two things as we get ready to wrap up, and thank you, Stephen, for not just for the content, but for the energy as the third panel today. That's really appreciated. First of all, we will also make the slides that we have permission to make available. I'll put them on our website and make those available. We also are going to post the videos, which will then include the slides, on our YouTube channel and on our website. So all of that will be available going forward. That's number one. Number two is that because this has been a Quattrone Center event, and because Dave Laban, who normally is up here, and kind of going back and forth with me, was not able to attend, I think it's really important to just sort of restate how valuable the partnership with the APA has been, and in particular, their role in identifying a lot of the speakers that we have and getting them here. So we really appreciate that, and I'd like to invite Nicole Parisi to come back and offer some closing thoughts as we begin to wrap things up.
I just want to say thank you again for making the trip here and really being engaged with all of the discussions and the presentations. It really is shown that you're committed to doing the right things for the right reasons. And on that note, I just want to reiterate that APA is a resource for you. We will really help in any way that we can. We make a joke with Dave that he never says no. It's a yes, but sometimes, but it's never a no. So if we can assist you, then we will direct you in the direction to the people or organizations that can. And so if you aren't a member already of APA, please visit our website. It's apainc.org. Become a member. You can learn about our upcoming trainings and conferences. And really, we just want to help you in your efforts to create safer communities. And then finally, I just want to thank again the Quattrone Center. Definitely know how to host an event. So I want to thank John for not only your vision and leadership, but really allowing your entire staff to help plan this event. Paul and Marissa and Anna, who's not here, who behind the scenes, she makes sure this event runs flawlessly. So thank you again, and we hope to continue this event next year. And if we do, we encourage you to reach out to us and let us know about any practices, any programs that you would like to hear about or like to present on. So thank you so much.
Okay, so thanks, Nicole, and I want to echo her thanks to my colleagues, and particularly the many folks that work here behind the scenes, everybody from the CLE processors, and by the way, make sure to submit your sheets upstairs on the way out, to the IT people who are here, doing the camera work and the posting and all of that stuff. We have literally dozens of people who help us do this, and it's great when people congratulate me for these wonderful events, because they do all the work and I get all the credit. So thanks very much. One other note, we will, if you enjoyed this session, our annual spring symposium, which has similar content in terms of innovation, but a broader ambit because it doesn't just focus on the prosecutorial role, will be April 2nd and 3rd, again, back here, so save the date. We'd love to have you back there for that, and we appreciate all of your time and attention and look forward to keeping in touch down the road. Thanks very much.